Good afternoon.
Good afternoon all. We're here for a hearing in the matter of CFI-021-2020 for His Excellency Justice Ali Al-Madhani. The claimant is represented by Evershed Sunderland, Rebecca Copley and Mason Alfiani. Counsel is David Craig, QC. He's on the telephone.
Good afternoon, Mr. Craig.
I'm sorry?
Yeah, I said good afternoon. Do you hear us?
Yes, we do. The line's a little bit muffled, but we hear you. Thank you.
Yes, lovely. If you give me a second, Jennifer, who's presenting this courtroom? Because this is an urgent application, it should be confidential. Do we know who's present in the courtroom now?
These are auditors, Your Excellency.
Auditors. Oh, this is ex parte. Is it, Mr. Gregg? Is this an ex parte application?
Your Excellency, it's on informal notice. We sent a copy of the application for alternative service to Mr. Olianju by email yesterday. We also sent it by courier and by email to GMG yesterday.
Right.
We hoped that there was a possibility, at least, that they would, or that Mr. Olianju would perhaps change his mind and give us an address for service in Dubai once he had seen that application, but unfortunately he hasn't responded to it. So in effect, we don't know whether he's looked at it, we don't know whether he's read it, and we, in any event, work on the basis that we will owe a duty of frank disclosure.
Well, I see that. Okay, I don't know if you're aware of this fact that the Deputy Registrar has informed me that a law firm within the DRC called KBH has called the court and confirmed they have received a service of the claim. I'm really not sure whether on behalf of the company, GMG, or on behalf of the second respondent. But I guess it's on behalf of the GMG maybe. So they are aware of the application now. But they have.
Yes, as we understand it, that law firm acts for GMG, so the corporate defendant.
Right.
But so far as we know, they do not act for Mr. Olianju. It may be that in due course they will do. But obviously we don't have a difficulty in serving on GMG Dubai Limited because they have an address in Dubai that we know we can serve on. And if in due course we can serve on their lawyers, then we can do that too. The difficulty really only relates to Mr. Olianju. Because we don't have an address for him in Dubai, and as you, I hope, would have seen from Mr. Berry's witness statement and from our Garrison argument, we have made efforts to get an address for service from Mr. Olianju by telephone, by letter, by email, and by WhatsApp, but he is effectively trying to avoid service.
Well, I have seen this fact from the witness statement of Mr. Berry, and I do follow this here. Well, Mr. Gregg, why it's not sufficient for you just to service the GMG itself as a company, if you manage to serve them and then you bring them to the application that to restrain them from employing Mr. Olianju, and why that isn't a sufficient process for you?
Well, we don't know at the moment what GMG might say in response to the claim, and whether they might have a defence that is open to them that would not be open to Mr. Olianju. So at this stage we take the view that we need to restrain Mr. Oleandru, who is our employee, and who is acting in breach of contract in working for a competitor. We at the moment don't see that he will have any defence to that claim at all, subject to his arguments about being constructively unfairly dismissed. But we simply don't know whether or not there might be a defence available to GMG Dubai Limited that would not be open to Mr. Oleandru, and so we want to ensure that in these proceedings we obtain relief against either one or both of the defendants. And Your Excellency, of course, you're right. It may well be that we would get an order against GMG, so that an order against Mr. Oleandru was ultimately unnecessary. But it may be that GMG would have a good defence for some reason that we haven't anticipated, in which case we would need to bring the action against Mr. Oleandru as well, as our current employee. So we want to ensure that we have an effective claim either way.
Yeah, I see your point. You saying that, I mean, the order against Mr. Oleandru is more important than GMG, because Mr. Oleandru is the contracting party with your company, and he's the one in the breach, and he is the one, who are in the breach of a contract.
Exactly.
I see.
Exactly, sir.
Well, I see. Okay, I'm aware of most of these facts now because of the evidence. Would you go on and tell me what is the method of service you want to do, Mr. Bray? The alternative service?
I'm sorry, Your Excellency.
Yes, I would like, would you please address me in the alternative services you wish to...
Your Excellency, I don't know if you have a bundle before you, but if you do, I want to ask you to turn to page 32 of the bundle.
$32, is that the draft order? I'm having it in draft order, is that right?
Yeah, this is the draft order, subject obviously to Your Excellency taking the view that it's appropriate to make this order, and if so, then we can obviously make arrangements to send you through a final version of the order. Yeah. One thing you will note, Your Excellency, is that in the third line of paragraph 1,
yes,
there's a reference to intended proceedings, because when we issued the application yesterday, yes, we have not yet issued the claim form, but we have now issued the claim form, so we do have a claim form index number. So the word intended should probably be deleted. But you'll see that we asked permission from the court to serve documents in this case, both the claim form and any other document that needs to be served on Mr. Oleandru, by two potential methods. One is to his personal email address, right, oleandru94@gmail.com, or by WhatsApp message to the telephone number there, which is his personal telephone number. And Your Excellency, I don't know whether you have seen this, but that email address, oleandru94@gmail.com, is an email address that Mr. Oleandru has been using recently. So if I could just ask you to turn back to page 26 of the bundle.
Yes.
You'll see at the top of the page, I know, an email that was sent by Mr. Oleandru from that email address on the 9th of January to individuals at TP ICAP. Yeah. And over the page, page 27 at the bottom and towards the bottom of the page, you'll see that he used that email address the week before on the 2nd of January. And Your Excellency, then at page 29, you'll see that he used that email address again only a few weeks ago on the 3rd of February, and we have no reason to believe that that account is not still active. So that is the personal email address that he has been using to communicate with TP ICAP.
Right.
And Your Excellency, then at page 31 of the same bundle, you should, I hope, see on the left-hand side of the page a screenshot of a WhatsApp message that was sent to Mr. Olianju's personal mobile phone. The message says, "Opie, I just wanted to confirm your email address and I've always sent you a letter that has no response. Andy," that's Mr. Berry. And Your Excellency, to the right-hand side of that, I think you can see 2 blue ticks.
Yes, I do.
And the 2 blue ticks signify that that message has not only been received, but that it has been read by the recipient. And that message was sent just last week. So as far as we know, both of those methods of communication should be effective to bring notice of proceedings to Mr. Olianju's attention, which is why, if you turn back to page 32, we have included both of those methods of service
So
in the
the
draft order.
reference to the Wednesday, that means Wednesday of the last week. Or when?
On Wednesday of last week, yes, the WhatsApp message was sent on the 20th of February.
I see.
Sorry, the 19th of February. It's paragraph 20 of Mr. Berry's statement on page 6.
Yeah.
So that was sent, on the 20th, so last Thursday, I think.
I see. What time is this? Would you please
What
tell
time
me?
is it?
Because usually it's supposed to, let's say, I don't know if you have used the feature that if you press on the message and then there is a feature can tell you when this message is delivered or what time. I don't know if you have this in second page or something. Oh, that's
I'm afraid I don't have that. All I can see is at the very top of the page, on page 31,
Yes.
I can see sometime 10:48 a.m. and 10:55 a.m. I assume that that's London time. But I'm afraid we don't. I know that the feature you're referring to, I think if you swipe across, you can see the time that it was delivered and the time that it was read. I'm afraid we don't know that. We do know that the blue ticks, I think, emerged on that day, on the 20th of February, so last Thursday.
Oh, I see.
But I can't tell you the precise time, I'm afraid. So, Your Excellency, if you order, please, at page 32.
Yes.
If you'll see a paragraph 1 with the amendment that I suggested, with the deletion of intended from the third line, we ask that the court make an order that it is to be served by sending documents to Mr. Olianju's personal email address or by WhatsApp to his telephone number that's there set out. That will be deemed to be good, valid and sufficient service of the claim form and other documents to be served on him in the proceedings. And then over the page, that we will provide notice of this order by sending it to those addresses. I should say we will, of course, also send it to GMG as a matter of courtesy. And at paragraph 3, that the date of deemed service of any document sent either by email or by WhatsApp will be deemed served on the day it's sent, if that's before 4 p.m. on that day. But if anything is served after 4 p.m., the deemed date of service will be the next business day. And at paragraph 4 comes in the case, obviously we don't give a different order because Mr. Olianju has not had full notice of this hearing, And it may be that he will try to set aside the order when the court to make it in due course, and obviously the court will have to consider that if he does apply to set aside the order. Your Excellency, I should just also draw your attention to, I don't know if you have our skeleton arguments, but that paragraph 23 of the skeleton,
Is it 23?
we have set out a number.
I'm afraid I didn't have that document.
You don't have that? Oh, well, can I just raise some... It may be right at the back of your bundle, but...
Well, I think your colleague just passed me a copy. Your colleague just passed me a copy. What's your name again?
Rebecca.
Rebecca. Yeah, Miss Rebecca has just, yeah. Passed me one, yeah.
I'm sorry that you haven't seen that. So, at paragraph 23, it's on page 5 of that document.
Yes, right.
We make 3 points that I should bring to your attention on full and frank disclosure. The first is that Mr. Oyanju may say that he's no longer in Dubai, or that he's not working for GMG, or that he's unaware of the messages that we have been sending him, and that he hasn't been obstructing service. Your Excellency, we say that is slightly unlikely given the matters that have been set out by Mr. Berry in his witness statement. But if that is Mr. Oyanju's position, then that will be addressed once he's been served. Secondly, there is an exclusive jurisdiction clause in his contract of employment in favour of England, but Mr. Oyanju, as we understand it, is presently in Dubai, he's working in the IFC. And obviously, as you know, our claim is for urgent interim injunctive relief to stop him from working for a competitor in respect of act in the DIFC. So they relate to his work for a DIFC registered company. And for that reason, we say it's fully appropriate that they are addressed before the DIFC court. But again, if Mr. Oyanju wishes to say otherwise, he can do so once he's been served. And thirdly, Mr. Oyanju, who I've already referred to, is likely to say that he's been constructively dismissed by the claimants. We take the view that there is no merit in that assertion, but that really is a matter for trial rather than for now. And as we say, that's really not relevant to whether there is a good reason for alternative service. And Your Excellency, we haven't seen the skeleton. It may also just be sensible to draw your attention to paragraphs 2 and 3 of the skeleton argument. Paragraph 2 sets out the rule that we make this application under, which I'm sure you're familiar with, where it appears the court will then do reason to authorise service by methods not permitted by this rule. The court may make an order permitting service by an alternative method. And then at paragraph 3, we set out a number of principles that have been applied as a matter of English law and procedure. Firstly, that it's not a prerequisite to the making of an order that service in accordance with the rules is impracticable. It's only necessary that there's a good reason. Secondly, that in deciding whether a good reason has been shown, the court should take into account the overriding objective of whether the making of the order will enable the court to deal with the case fairly. And thirdly, the most important purpose of service is to ensure that the contents of the relevant documents are communicated to the defendant. And then finally, just on the authorities, and I can take you to them if you want me to, but at paragraph 20 of our skeleton,
20 years.
Just an extract from the judgment of Justice Sir Jeremy Cook in a DIFC case, Pearl Petroleum Company versus the Kurdistan Regional Government of Iran, who deals with Rule 9.31 of the DIFC court rule. And he says the clear intention of the alternative service provisions is indicated of a situation where a party is obstructing service, and to do so whether the defendant in question resides in or outside the court's territorial jurisdiction. And Your Excellency, you obviously have the point, having seen this very written statement, that we do say that Mr. Oleanju is trying to obstruct service because we have tried by email, by telephone, by letter, and by WhatsApp to get a response from him, both to give undertaking in relation to his conduct and to agree that he will not continue to work for GMG, but also to try to get an address from him for service, and he has just failed to respond to any of those attempts at communication, even though, so far as we are aware, he has received those communications. And we say the irresistible inference from those matters is that he is trying to avoid service. So that there is good reason in this case to permit alternative service in the way that we seek, and that the court we respectfully invite to exercise its discretion to make the order so that we can serve proceedings on him by email and by WhatsApp. And Your Excellency will understand that our intention is to issue the application for urgent interim injunctive relief either later today, or if we can't do it later today, tomorrow, so that we can get on before the court as quickly as possible to restrain and continuing breach of contract. So there is room for
You mean
from our
urgent
perspective
with
to get
notice? It's not the next part, isn't it?
Yeah.
Yes. Well, Mr. Greg, I think if you can tell me why you have not started this proceeding in the UK court and have, gained an injunctive relief from the court of jurisdiction where the last known address of Mr. Oleanju, for example, and then you serve it to the DFC instead of, yeah.
Yeah. The simple reason for that at the moment is that, so far as we know, Mr. Oleanju is in Dubai, and an English court can be reluctant to grant an injunction against an individual who is not within its jurisdiction. Because the English court will often say it should not make an order against someone who is not within the jurisdiction. The other difficulty we have is we can have the same difficulty with service. We could serve on his last name address, but if we believe that he is in Dubai, the court may well have difficulty with that, so that we would potentially have to go through exactly the same route. But we also, part of the reason for bringing the case to Dubai, therefore, is one, we know that Mr. Oleanju is there, and the court therefore should have jurisdiction over him. But we also have, as Your Excellency rightly identified earlier on in our discussion, we have an entity in Dubai. So either way, we hope that we'll be able to get an order that is going to prevent Mr. Oleanju from continuing to act in breach of contract. But as I say, there are potentially difficulties in the way of an English court granting an injunction against someone outside the jurisdiction.
Well, I see. Then, okay, my next question is that your intention to serve him through his email address and WhatsApp through his mobile. It's not or, isn't it? It's and. So for both addresses, isn't it?
Yes, yes, I suppose that's right. We can do both. Well, I think we will do both. It may transpire once he has been served,
yes,
he will agree to service by email, for example, and therefore we wouldn't need to serve it by WhatsApp and email. So that's why we have put all for the time being. But we can certainly undertake, if Your Excellency is concerned about that, certainly in relation to the application for interim injunctive relief, that it will be sent to both.
Well, right. What's in my mind is that I want to add his English address as well, by courier maybe.
Yeah.
Would that be fine?
Yeah.
So that would be C.
Yeah, of course.
Yeah.
Yeah. Your Excellency, when you say his English address, I think we understand it's actually his parents' address. but it's the last name address we had for where he was living. I take it that's what you have in mind.
Which is referred to in his employment contract, isn't it? Is that the address?
Yes, Mr. Berry refers to the fact that we did write to him at this address, but that we understand, or he understands, that it is his parents' address. That's at paragraph 15 of Mr. Berry's witness statement. But you're right, we understand that to be his home in England when if he's here.
Yeah.
That would be where he would reside, and I assume that's the address you have in mind.
Yeah, if that's the only address, I think I'm intent to include it.
Yes, very well.
Well, Mr. Craig, I think I have heard enough from you, and I think I'm with you. I'm in favor of granting the order. I'm satisfied with the evidence you have. Supplied to court, and I do agree. I will grant you your order that for alternative service of Mr. Olianju and his email address and his WhatsApp and the telephone address that's provided +447539446939 and to his English address to be served by courier.
Yes, by courier.
Yes.
By courier. We're very grateful, Your Excellency. Would it be helpful for us to amend the order to reflect Your Excellency's ruling and email that through to the registrar?
Well, yes, if you can do that on an urgent basis, yes, we would be willing. We will close business within less than an hour. If you can do that as soon as, we can provide you with the order today.
Yes. Yes, that's very helpful. Thank you. We will do that as soon as the hearing is completed.
That's fine. Application is granted. Cost in the case.
We're very grateful.
Lovely. Thank you very much, Mr. Gray.
Thank you.
Cheers.
Thank you.
Yes, Jennifer.
All rise.